Well, a judge ruled today that the Liberal government's use of the Emergencies Act 2 years ago was unreasonable. However, the government is appealing the decision, saying it was within charter rights to use the act to clear so-called Freedom Convoy protesters from Ottawa in 2022.
All right, we have Rebecca Sheppard from Stand for Thee. How you doing, girl?
I'm fantastic, Shade. How are you?
I'm doing very, very well. And of course, we have Brother Damaduch here. He's doing fantastic. I'll speak for him. And I was excited to talk to you today because, of course, we had a ruling, I believe, from the federal court. So why don't I let you, because I know you know a little bit more about this, explain to the folks what this ruling was, what your thoughts are on this ruling, your general idea. Maybe let them know what he was found guilty of.
Okay, so first I'm going to apologize for the bad lighting, folks. I'm sorry about that, but I know you can still see my beady little eyes, so that's all that counts. Okay, so the Emergencies Act, Judge Mosley ruled that the invocation of the Emergencies Act was ultra-virus, meaning without lawfulness. That's not the right word. Basically, they acted above the law within regards to the act because they didn't meet the requirements of Section 16, which were the grounds to invoke an emergency under the Emergencies Act. There are 4 types of emergencies in the Emergency Act. There's the public welfare, public order, and there's 2 other ones which escape me at the moment. But the public welfare one's important too, because why didn't they invoke that for the quarantine stuff, right?
Okay, so what this is really primarily about, so that just people understand, this is about how he, quote unquote, invoked the Emergencies Act, right?
It's not how he did it, it's the grounds that they used for it.
Okay, and it didn't cut the deal, like they
meet
the requirements.
So public order emergency means that there's a national issue which could be in a risk to the public safety or national security. But then it also references the CSIS Act, Section 2, which defines what that the threat is. And you know how they kept trying to label everybody as terrorists and this nonsense of foreign funding, which was just people donating through the different platforms, Give, Send, Go, and GoFundMe, right? That's not terrorist activity. Going back to the CSIS Act, again, the grounds are specific. And even David Vigneault, at the time, I don't know if he still is the head of CSIS, but during the Public Order Emergency Commission, even he said that CSIS didn't ask for the act to be invoked, and that I think it was Lametti who said in the Public Order Emergency Commission that they decided to change the definition of Section 2 of the CSIS Act to meet the requirements of invoking the act. So they didn't actually meet. So the grounds are twofold, and the second part is the requirement of Section 2 under the CSIS Act. So that's one thing. So that's ultra-virus, meaning they acted above their lawful authority in implementing the act, okay?
Okay.
It's actually implementing the regulations under the act. The act already lives. It's the orders in council that come under it.
Because you were mentioning to me before we started recording, because I was asking you, well, like, is this a charge on Trudeau, on the Liberal Party? And you said neither. No. It's a judicial review.
Which is interesting in itself, because if you look at this in comparison to Sean Rickard and I think Brian Peckford's judicial review, which, again, they keep trying to get a new one. It's like, no, listen. The government's told you a million times you're not getting a judicial review. Maybe it's time to move on, but I digress. So a judicial review is asking the courts to look at a law and make a decision around it. So, for example, does it violate my rights? Was it implemented lawfully? Was it basically challenging the implementation and comparing it to a legal framework, legislation, or in this case, the legislation itself, and then a judge, or I guess it's the judge. I'm so used to saying or JP from POA, will determine an outcome of that law.
Now, at the same time, now, if I recall correctly, because obviously we say we shouldn't use the charter, right? And we know why, because Section 1, et cetera, right? It kind of limits people's rights. But in this case, they did use it. And I'm just going to say something here. I was thinking that in this case, it's because it's not about civil liberties of the citizens, then in this case, it wasn't as damaging. And they could also, if I recall correctly, I was hearing someone was also using the Canadian Bill of Rights because both the Charter and the Canadian Bill of Rights are in the Emergencies Act.
Yeah.
Any thoughts on that? Because I'm sure some people want to know, because, even Dom and I were talking about this, and Dom was like, I have a concern that, if they show like there's a win with the charter, see, the charter really is good. And we're like going, no, it's not.
100%.
Okay.
I think, again, I'm just speaking as, I'm not a legal expert. I want to make that clear. I'm not trying to lay claim that I know everything, because I'm not. I'm just telling you what I believe. I'm telling you what I believe to be true based on what I know to be true with regards to the charter and the bill and these laws, because I've been digging into the Trudeau for Treason for some time now, as you should know. And so I think what facilitates the charter win is the fact that going back to these committees and the POEC, the police at all levels stated that they actually had the legal authority outside of the act to shut down the protest, which is the Criminal Code of Canada. I believe it's Section 63.
They had the authority, or they didn't?
They did. They didn't need the Emergencies Act. Brenda Lucky, who at the time was the commissioner of the RCMP, stated that they had tools. They had tools, they had not used all available tools. So the Emergencies Act is only supposed to be invoked in like the last resort. We cannot fix this any other way.
So what you're saying really is essentially the police, the Ottawa police specifically, they had the juice and the jurisdiction on all levels to do. They didn't actually even need the Emergency Act to be invoked. So
called
then
the Criminal Code of Canada. There's a lot of things that they could have used as grounds, right?
Okay.
But they didn't. They didn't even try. They did not even try to get people off the streets. The whole 2 weeks, there was no attempt to move anybody. And to your point, Shade, I feel like it's going to cause, don't get me wrong. This is good because we're going to make it good, because we're going to take advantage of it. We're going to make this an opportunity. And it is good to see that it's beyond our scope, right? Those of us that know it was BS. It's good for the normies to see from mainstream, from a judge, that, oh, crap, maybe our government did break the law, right? So it extends beyond us.
Yeah. So there is some imaging here that we want to appreciate, that
Absolutely.
Those of us who are saying, look, this, he had no grounds to invoke this. He certainly didn't have the positioning to do it. There was no need for it, of course. And of course, we have the freedom and rights to protest. And plus, it did illuminate as well, by the way, that the Canadian Bill of Rights is in the National Emergencies Act, which proves what we've been saying all along, that the Charter did not override the bill. Otherwise, the bill wouldn't be in there, because that received royal assent in 1988, which meaning the National Emergencies Act. And of course, the Charter was popularized, I'll use that term, in 1982. So if you still are putting in documents in 1985 and 1988, which is the National Emergencies Act was created in 1985. In 1988, it received royal assent, and the bill is in there. So that kind of helped us prove that it did not get overrided or did not get eliminated or anything of that nature. So there's some really good stuff out of that. And at the same time, of course, eventually a judicial review saying Mr. Trudeau acted out of bounds along with his party. And so that's kind of putting a few, flags on our part to say, we told you that this was inappropriate, and these are civil liberties that he's violating. And so that's all good. But at the same time, we don't want to turn around and say, aha, we win and it's all over. So this is kind of what's leading me to the next question here, because we're seeing some let's say, maneuvers they could make to kind of just make this, because we're not really hearing about, okay, so what's the retribution here? Where's the punishment? Who's going to, is there any payment to this? Or are we just going to say you were a naughty group of people? That's very bad. And that's it. Like, what's going on with that part of things?
That's it. I want to clarify something because this has come up. Nobody was charged under the Emergencies Act because there was nothing to charge you under the Emergencies Act because nobody was doing those things. Okay. So they didn't use the Emergencies Act when they were laying charges. They used the criminal code, which couldn't they have done that from the beginning? Right.
Right.
And they used mischief, and they used mischief and something, conspiracy to commit or something like that. They used,
because you're talking about the charges that were put on citizens.
Yes.
Right. Okay.
After the Emergencies Act was invoked, which actually now saying this should lead to suspicion that maybe the regulations didn't have that much power. I mean, they did for the finances. The RCMP gave the bank people's names, and the bank went, okay. So those people had their accounts taken specifically from powers that came from the regulations under the Emergencies Act. All of the other people that have criminal charges, those criminal charges were not from the Emergencies Act. So those people that were charged in Ottawa or in Windsor or Coutts or wherever, I want to make it clear, those were not regulations. Those were not charges stemming from the orders in council. Those were not charges from the regulations. So I just want people to understand that because, and it took me a minute to piece that together as well, because I had also told people, well, you should get your charges stayed. And then I was like, well, wait, those charges are not under the regulations.
Okay, so because what you're speaking to is that there's some people who got a lot of these charges that you're listing, that this particular victory for us won't actually even help them because these weren't charges that have anything to do with this invoking of the Emergencies Act. So the only exception, clever. Yeah, very clever. But what you are saying is that the people who were charged, or like let's say got their bank accounts frozen, those are the folks that might actually have a case. Is that what you're suggesting?
Oh, absolutely. Well, everyone has a case here. And
okay.
You got options here. So number one, you can do a laying of an information, right? Private charges.
Okay. And who would they privately charge?
Well, the executive branch. The executive branch. And there's tort laws for this too, right? It depends on what happened to you. Some people had their property stolen, like their trucks. Some people had their trucks damaged. Some people were unlawfully, were detained.
Some people were beaten. Some people were physically hit.
Yeah. And the thing is that there are people who were detained but not charged. There are people who had their properties taken but not charged. So there's varying degrees of impact to different people, right? So it depends on what your situation is. So you can do laying of an information, and that there's a bunch of different things to choose from there. And then there's also the civil action. So, of course, we're fond of small claims, right? And actually, there's been a few people. Actually, Dave's going through small claims court right now too. I should check in on his status.
She's speaking about Dave Freedom, in case anybody wants to know.
Oh yes, Dave Freedom.
Yeah, no
Bless
problem.
him. Bless Dave Freedom. All I know is we got this ruling, and let's take advantage of it. Let's make this an opportunity. Let's roll up our sleeves and get to it, because you only have 2 weeks. You only got 2 weeks. So let's do something with this. And
when you say they only have 2 weeks, is there a particular reason why
statutory limitations on lawsuits?
Okay, so the main focus at this point now is to move people to join in on your email list. And by the way, and then this Zoom call, especially on Monday, which is, if you don't mind me getting the exact date, that's February
5th at 8 o'clock.
February 5th, 8 o'clock, yeah. Stand for thee.
Yeah. Tomorrow, we're going to be talking about the grand jury. We're still working through the list to get grand jurors, and people can still register. But we need to move forward with this. We need to do everything that we can to hold these people accountable.
Okay. So that's the main thing we want to deliver. We want to deliver the message that this is overall, this is a good win. It's a good victory, but it's not a complete victory. And we need to kind of keep smacking while the iron's hot.
We need accountability. And
Right.
we now have a mechanism to seek that accountability.
Okay, that's great, Rebecca. Thank you so much for sharing all this information. And we're going to try to get this video up tonight so that people can know about it and find you. Thank you, Stand4Thee. And for all of you who want to know, many I'm sure know already, but just, STAND, the number 4 THEE. And I think it's .ca or .com, right?
Yeah.
All right. And you can be found on Facebook as well. But again,
Instagram,
if you can.
Telegram, Facebook, Twitter.
Thank you so much for sharing this information with everyone. And I really want people to tune into what you got going on. And I know a lot of people are going to be excited about it. So thank you so much for taking this time with me.
Thank you so much for having me.
You got it. I'll talk to you soon.
Always a pleasure.